Okay. I need to screen share. Let's do that one. All right, are you guys seeing my screen?
Yeah.
Okay, good. All right, so we are going to, first one we're going to go to is just a straight addendum. And I think everybody that we've got here is pretty well versed at how to do addendums, but I'm going to just go quickly into it just because we've got a couple of people that I know wanted me to record this. So we're going to go into forms. We'll just pull up an addendum. So on a blank addendum, make sure that you number it at the top accordingly. If it's the first addendum to your contract, you make sure you put in your number 1, or make sure that you change that. It doesn't matter, even though it says addendum number 1 in the on the sheet, you have to number it once you open it up here. Buyer or seller, landlord or tenant, who is the one that's initiating this. The agreement of the contract dated with it. That's the date that of your contract, not the date that the contract was written, but the date that the contract became a ratified contract. So it depends on when the seller or whenever the last counter offer or whatever was signed. That's the actual date of the contract that you're going to want to put in. Seller, landlord, tenant, buyer, premises address, all pretty self-explanatory. But then when you come down into the section of the addendum itself, I'll just kind of show you a personal preference of how I like to write the addendum when I'm actually writing the addendum. I always like to either put 1 star or maybe a couple of stars just to kind of denote that this is something that I'm changing to the contract. And if it's something we're doing in here, it's again, addendum is only after we are under contract is when we're doing an addendum. Otherwise, we'd be doing a counter offer. So let's just say that and you can word that numerous different ways, but basically, really, that's all I really wanted to show in there is that that's kind of what I do, and then I always underneath it put just to make sure everybody understands that all other terms and conditions are to remain the same. Does that make sense?
Okay, yeah.
Sharon, I can't hear you very well. I don't know what's going on with your microphone.
Yeah, I'm in line. Sorry. Yeah, I can hold her. You have your one of your debit card. I can hold mine. Okay, sure.
You should mute her, Todd.
Okay, I thought she was actually asking a question. All right, so I muted her. Okay, good. All right, so that is basically all I really wanted to cover on just the plain addendum, is just how to quickly put your stuff in there, how you want to address it. Patty, is there anything that you would like to add on how to do an addendum?
Nope, that's exactly what I do.
Okay, good. So nice and easy, and we're just going to exit. We're going to go back out to forms. Next one that I was going to cover is the appraisal contingency. So the appraisal contingency notice is the next one I'm going to jump into. And especially with what's going on today, I think, people are asking, well, how do we notify if the appraisal comes in short? What do we need to do? Well, we know that we need to notify the seller within 5 days what our intent is, as what the buyer's intent is. So you'll use the appraisal contingency form, again, contract dated, buyer and seller, escrow company, premises address, and then it's just got the 2 choices. The buyers receive notice that the premises have failed to appraise and they elect to cancel the contract and receive a refund the earnest money, or the buyers receive notice that the premises have failed to appraise of the sales price and elect not to cancel the contract. Buyer acknowledges that the appraisal contingency shall be waived, and if buyer is unable to obtain a loan without conditions due to the waiver of appraisal contingency, buyer shall be in breach of contract. So one of those 2 choices. Now, before you fill this out and send it over, you're always going to want to have that conversation with the listing agent and just make sure that you can't come to some other agreement, because there are other choices other than going forward, or other than canceling, or going forward and the buyer paying all the money. You can have an adjustment where you would need to adjust the purchase price down to meet what the appraised price is, or you can negotiate out, maybe the buyer comes down some, or goes up some and the seller comes down some. there's a number of different ways that you can come to an agreement. But once you come to that agreement, then you're going to want to use the appraisal contingency notice just to make sure that everybody's on the same page as to how you're going to proceed. Anybody else want to add anything with that one? All right, we're going to go to the next one, to the buyer contingency. So we'll go back into the forms, buyer contingency addendum. So we'll open that one up. Again, the top part is pretty self-explanatory, but you're going to use this form, this buyer contingency addendum, if your buyer has a contingency either to sell their house or close on their current house that they have. So you're going to want to use this buyer contingency form rather than trying to write everything up. It's very nice that we have these forms that are already all spelled out and how to use them. So the following additional terms and conditions are hereby included as part of the contract. Premises if marked by an X and initialed by the seller and buyer. The terms and conditions of the contract are included herein by reference. So you don't have to put that little term. All other terms and conditions remain the same because it's right there for you. So the first one is contingent upon acceptance of an offer for the buyer's property. So this is if you don't even have the other, if you have the other, if your buyer, if their house that they're selling, it may not even be on the market. But if it is already on the market, but you don't have a contract on it, you're going to want to put in their current house that they're trying to sell on that line. And then the date that it has to be under contract by. So you want to have it under contract, have an accepted offer by such and such date. That's always going to be a negotiable term, but you want to make sure that you're not leaving the seller hanging out for a long period of time trying to get your buyer's home under contract to start with. So that's you're going to want to make that as short as you possibly can in order to still make your offer attractive to a seller. And right now, everybody knows in this current market, it's going to be almost impossible to get a contingent offer accepted unless the seller is just, desperate to get the place sold and hasn't gotten any other offers. So this first section probably isn't going to be used all that much right now, but hopefully when we get back to a normal market, it will be. Accepted offer for the buyer's property. If the buyer accepts an offer on buyer's property by the date set forth on line 10, the buyer shall deliver the accepted offer documents described in lines 67 to 72 to the seller for the review within 3 days or blank days of the execution of the accepted offer. If buyer accepts an offer on the property yet fails to deliver the accepted offer documents to the seller within the time frame set forth, the seller may issue a cure notice to buyer as required by Section 7A of this contract. And in the event of the buyer's breach, seller shall be entitled to earnest money. So you need to make sure that you're communicating with that with the selling agent and make sure that they know that once you get your people's home under contract, that you're providing those documents to them right away, so that if they cure you, your buyer won't lose their earnest money. If the seller does not cancel this contract within 3 days of the receipt of the accepted offer documents, this contract shall become contingent upon the closing of the pending sale of the property by X date. So normally you're going to want to give yourself, if on this first line up here, if you're putting in here, let's say today is the 21st, if you're going to give yourself until the 28th, you're going to give yourself a week to get this under contract, then you're probably going to be a month after the 28th would be the date that you would put down on line 21. Give yourselves a month to get that one closed, or hopefully you'll have, I would give yourself at least a month to get closed. If hopefully you can get it done sooner than that. If the pending sale of the buyer's property does not close by this date, the contract shall be deemed canceled and the earnest money shall be released to the buyer. So if their home doesn't close, then they can still get their earnest money back. That keeps that contingency in place. Cancellation of accepted offer for buyer's property. If buyer's accepted offer cancels for any reason, buyer shall deliver notice to the seller within 3 days of the receipt of the cancellation, provide evidence of cancellation. Notice to the seller shall be buyer's election to either, number one, immediately cancel this contract and return the earnest money. 2, proceed with this contract by removing the contingency and provide 1, written documentation for the buyer's lender that the buyer can close escrow by the close of escrow date without the sale of their other property. Or 2, if this is an all cash sale, evidence of buyer's financial ability to close escrow by the close of escrow date without the sale and closing of buyer's property. So really, you just need to show evidence that they can still close escrow if their property cancels. And if you can't, then they need to cancel this. They need to cancel this contract and get out. If buyer elects to waive the buyer contingency and proceed with this contract, buyer and seller agree that all other contingencies shall remain. So you'll still have all the inspection contingencies and all the other stuff will still be in there. Seller's acceptance of a backup contract. If seller accepts a subsequent offer or backup to purchase the premises before the buyer has delivered to the seller and accepted offer documents, seller may deliver written notice to the buyer informing the buyer of the backup contract. Upon receipt of the seller's notice, the buyer has 3 days to deliver to the seller a written notice to remove the contingency. Such notice from the buyer shall include written documentation from the lender that they can close escrow without the sale of their other house. If this is an all cash sale, evidence of the buyer's financial ability to close without the sale of the other property. If buyer fails to timely waive the buyer contingency, the contract shall be deemed canceled and the earnest money shall be released to the buyer. So that's kind of a big piece right there. If the buyer fails to timely waive the contingency, the contract is deemed canceled. So that doesn't mean that they are in breach. It just means that it's a canceled contract. If buyer elects to waive the buyer contingency and proceed with this contract, seller and buyer agree that all other contingencies shall remain. Time periods. The date of the contract acceptance for the purposes of all applicable contract time periods, excluding opening of escrow and deposit of earnest money, shall deem to be either one, the date that the signed contract and any of the incorporated counter offer is delivered and received by the appropriate broker as indicated in section 8I of the contract, or 3 days after the seller's receipt of the buyer's accepted offer documents, provided that the seller does not cancel the contract prior to the expiration of the 3 days. So an election just needs to be made there as to what you're construing as your time periods. Contingent upon the closing of a buyer's property. So the first piece up here was contingent upon the sale of a property. Now or you can do a contingent upon the closing. So if your buyer already have their house under contract and you're just waiting to close escrow, then this is the option that you would use. The buyer has already accepted an offer, given the address, buyer's contingency. If the pending sale of the buyer's property does not close escrow by X date, this contract shall be deemed canceled and the earnest money shall be released to the buyer. Cancellation of accepted offer for buyer's property. If a buyer's accepted offer cancels for any reason, buyer shall deliver notice within 3 days. Then the buyer will immediately cancel this contract, or they will proceed with the contract and again provide those details that they need in order to show that they are capable of actually going forward and closing the contract. So the time periods, the date of the contract acceptance for purposes of all applicable contract time periods shall be the date that the signed contract and any incorporated counteroffers are delivered and received by the appropriate brokers. Delivered and received by the appropriate brokers as indicated in 8I. The following terms to either contingency agreed to above. Accepted offer documents. Within the time period, the buyer shall deliver accepted offer documents to the seller, including the purchase contract documents evidenced in the sale. And there are several other, they leave you several things there that you could also require. You may want to have the information on the other buyer of their property. You may want to have, the loan information for them, or there may be some other information. Maybe you want proof of funds for something along those lines. Those would be things that you would put in there as other documents that you would ask for if you were, or that you would want to supply if you were having a contingent offer. Is there anything other in there, Patty, or anybody else that you can think of that you might want to add in there if you're taking a contingent offer?
No, I agree with that. Pre-qualification, proof of funds.
Yeah, I guess maybe if it was a relocation transaction, you'd want to have some kind of documentation from the relocation that they have accepted the property, that kind of thing. But there might be some other things. They just give you several places there in case there are things that you really, you feel are pertinent to making sure that you're getting the contract accepted and it's legitimate. Failure to deliver notice. If a buyer fails to timely deliver the notice required by this addendum, the seller may issue a cure notice to the buyer. And in the event of a buyer's breach, seller shall be entitled to the earnest money pursuant to Section 7B of this contract. Status update. Upon request, buyer shall provide seller with a written update regarding the status of the sale of buyer's property. Notice that it leaves it pretty vague there. It just says upon request, the buyer shall provide the seller with an update. So they could require, that if the seller is asking every day for an update, this really says that the buyer has to provide the seller with a written update regarding the status of the property. I don't think most sellers are not going to want an update every day, but I think it's kind of unusual that they wouldn't say it, maybe once a week or every 10 days or something like that, that they would require it, but they leave it pretty blank for you. Anything else that anybody wants to add into the buyer contingency addendum? All right, so we're going to go back, and the next one we're going to go into is the consent to limited representation. So the limited representation form. So often called the dual agency form. So this is if your broker is representing the both buyer and seller in either a lease or a purchase transaction, you have to have this consent to limited representation. So this is whether you're representing both sides or whether the brokerage is representing both sides. You need to have this form completed and filled out with everybody's information up top. And then down here, it says buyer and seller consent that the broker acting through the licensee name below represent both parties in the transaction. With one licensee, you would put the name, or if it was two licensees, if you were representing buyer or seller and one of our other agents was representing the other side, you'd put both names in there. And it just goes through and it gives duties and limitations, and it really spells out what they are giving up as rights as far as having dual representation. There are certain things that you're not going to be able to do and exercise as one of the as representing both parties. But it does say that you still shall there are limitations, but you still have to operate with reasonable skill and care and performance of your duties, and you're obligated to deal honestly with both parties. And the duties of the licensee in this transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. So it's kind of a warning to them to make sure that you're understanding that having one agent representing both sides is limiting your representation. Prior agreements, seller and buyer understand this consent does not replace prior arrangements or agreements entered into with the broker, and such agreements shall remain in effect. However, to the extent that the terms of this consent contradict or conflict with those terms, this consent shall supersede. If the buyer and seller do not enter into a contract relating to the subject property, or if the transaction between the buyer and seller fails to close, the parties agree that this consent is terminated, and the parties shall have no further rights or obligations pursuant to of this consent. So if you cancel out of that transaction, this limited representation goes away, and you're back to your normal agreement that you have as far as how you're representing buyer or seller. Buyer and seller agree to indemnify and hold harmless against all claims, damages, losses, expenses, and liabilities, including attorney fees and costs incurred by broker in any defense thereof arising from the broker's role of limited representation. That's a big piece in there for us that takes us off the hook if something were to arise that happened to be because of dual representation, that says that they can't come back at us for it because we've explained it to them. Any questions about the consent to limited representation?
Yes, I do, Todd.
Yes.
So what are the things that we cannot do when in this situation?
So if you are representing both parties, well, that's the broker represents, well, we'll just go through that real quick. They can represent interest into both to the exclusion or detriment of the other party. Parties understand and further consent to the following. If they represent both parties, the licensee will not, without written authorization, disclose to the other party that the seller will accept a price or terms other than stated in the listing, or that the buyer will accept a price or terms other than offered. So that's kind of one of the big things that you come across is normally when you're dealing with a seller, if you have the listing, generally you're that you're listing it for X price, but you have had conversations about, well, if we don't get an offer by this date, we can come down to this, or they may come flat out and tell you, as long as I can get 350 for this house, I'm going to be happy. Well, that 350 is their magic number. At least they can get that. You can't disclose that to the other party. You can't disclose that to the buyer. And it's unfortunately amazing how sometimes you get down to that pain threshold point of where what they are willing to accept is where an offer comes back in. And that's where it can look very dangerous on your part. I mean, if you say, if you've got your buyer and you and your buyer are trying to come up with a price as to what you're going to offer, and if your buyer comes up and says, well, I think we should offer 350, you've got a red flag going off in your head going, oh, crud. These guys have already told me that they would take 350 as their lowest price. And now these guys want to offer 350. That can put you in a very precarious situation. So you just need to be very careful with situations like that, that you don't disclose anything that you shouldn't, especially as
Okay.
far as selling price or terms or things along those lines, things that would give the buyer an unfair advantage or the seller an unfair advantage. If you are representing if you've got this and you've got the buyer on your side as well, and the buyer said, well, I'd be willing to go up to 350 or 360 on this property, I'd be willing to go that high on it. And it's amazing, all of a sudden the seller, he agrees to come down to 350 or 360, whatever that is. And now your buyer's going, well, did you tell him that that's what I would do? So it gets really dicey when you start talking about pricing and terms and that kind of thing when you're representing both sides.
Okay. Okay, thank you.
Yep, and it says right there will be conflicts in the duties of loyalty, obedience, disclosure, and confidentiality. Disclosure of the confidential information may be made only with written authorization. This does not relieve the licensee of any legal obligation to disclose all known facts that may materially and adversely affect the consideration. So if you still have a material fact that you still need to disclose that. All right, any other questions about disclosure part of that? Okay. Next, we're going to go to the coronavirus addendum. This one I'm hoping we will be stopping using completely before very long. Has anybody used one of these forms in any of your contracts? Kenneth, I heard a sigh. Was that
Nope.
a yes?
That was a no.
So I personally haven't either, and I don't know. Amy, I thought that maybe you had used one of these in one of your contracts, but I don't remember for sure. So the coronavirus addendum really came out last year, March of 2020, and it was put in as kind of a protection for, and mainly I think this is geared toward buyers, to protect buyers in the coronavirus, that it really allows them an opportunity to cancel and get out of the contract at just the mere threat of saying coronavirus. But if you go through it, top part's all the same. The current worldwide virus pandemic has impacted real estate in many ways, including but not limited to travel, self-imposed and governmentally required quarantines, and closure of both governmental and private offices required to fund, close, and record real estate transactions. Because of the unprecedented nature, buyer and seller are hereby advised to seek appropriate counsel from insurance, legal, tax, and accounting professionals to better understand obligations. So that piece is good there. I think that's a nice little disclosure there, just to say, hey, you should probably seek counsel if you have, if there's anything that you want to, that you want to look at that might be related to the coronavirus. A variety of issues outside of the control of the buyer or seller may impact this transaction and affect all parties' contractual performance. As a result, the following additional terms and conditions are hereby included as part of the contract between the buyer and seller in the above referenced premises. Only those items checked are hereby included as part of the contract. All other terms and conditions of the contract remain unchanged. So if you don't check any of these boxes, that's great. All you're doing is you're just providing an addendum that says you should seek out counsel and make sure that you understand. But if you decide to check one of these boxes, you can put this addendum into place. You don't have to put it right straight up front with the contract. You can add this in at any time. So what you can do is you can say the date of the close of escrow is hereby postponed and extended to X amount. Let's just say you have somebody that either the buyer or the seller gets the virus and they have to quarantine and they can't close at that amount of time. You would be able to use that piece right there to say, we're just going to extend it and extend your close of escrow until that point, until that date. Notwithstanding any other provisions of the contract, buyer and seller acknowledge the possibility that the buyer, the lender, the seller, escrow company, or appropriate recorder's office may become subject to voluntary or mandatory COVID-19 quarantine or closure prior to or at any time of close of escrow. Should such event occur that results in the party's inability to perform, the buyer and seller agree that the closing may be automatically extended by either party via written notice for a period of up to 10 days after such quarantine is over or closure is lifted, unless the party otherwise mutually agree in writing to further extend close of escrow. So that would just automatically push it out another 10 days if you check that box. If there was anything that happened, if anything said that, if any party said that there was coronavirus was preventing them from being able to close. Now you notice in here, it doesn't say anything in here about you have to have a doctor's note or you have to show proof that the coronavirus prevented you from doing it. It just says you really it's up to the buyer or seller or whoever to say, yeah, I have, there's coronavirus is preventing me from doing that. So we're invoking that piece of the contract. That's why I don't really like this, is because there really isn't anything in here that says that you have to show proof of it on that one.
I agree, Todd, especially if you're a seller and you've got to close on something else, or, I mean, it's can put you in a very awkward position.
Right.
If, somebody just for whatever reason.
And it can be hearsay. I mean, and it doesn't, a buyer could come up with any reason in the world that, there's a number of reasons why they may either not want to or can't perform and can't close escrow. And you can just say, oh, coronavirus, I've got this box checked. So, we're going to, postpone everything for at least 10 days until, our quarantine is over. It's because it says after such quarantine is over. And it doesn't even say who's imposing the quarantine, what the quarantine may be, how long it might be. So it just says that you can extend it 10 days past whatever the quarantine is, it could be a self-imposed. It even says self-imposed quarantine. So yeah, I really don't like the vagueness of how that was written.
I'm curious, are we seeing many people even use this now? I mean, it was
Very few. Very
I'm
few.
not seeing it at all, really.
There's still a few brokerages out there that there are a couple of them that are requiring this to be a part of the contract, a part of their buyer or their seller, or the seller needs to have it in their contract. And I really can't disagree enough with having to make this a part of the contract. And again, it depends on which box you check. I mean, if you make this part of the contract, but you don't check any boxes, fine. That's fine. No problem. As long as we don't have to check any of those boxes and agree to do any of that nonsense. And then it says, notwithstanding to any other provisions of the contract, buyer and seller acknowledge that the possibility that the buyer, lender, escrow, appropriate recorder's office, subject to voluntary and mandatory COVID-19, subject to of a voluntary or mandatory COVID-19 virus quarantine. If it happens, should such an event occur, that the results in the party's inability to perform on the close of escrow date, buyer and seller agree that the closing may be automatically extended by either party via written notice for a period of up to 10 days after the quarantine is lifted. This delay shall not exceed 30 days in total unless parties otherwise mutually agree. So this one at least says the worst you're going to do is go out 30 days. So it's going to give the worst you're going to get is 30 days. So I do like this one better than the one up above it. The one up above it has no limitations. This one, it says the delay is not going to exceed 30 days. So worst case scenario for your seller on this one, we have to push it a month based on coronavirus. Unless you have something mutually agreed upon outside of this addendum. Upon the expiration of any automatic or agreed extension, either party may terminate this agreement in writing without any further liability to the other party, and the earnest money shall be released to the buyer. So that one right there, it says you can terminate, you can cancel. If you're a buyer, this gives you another out for the whole period of being in escrow. I mean, you can really, any other reason that you can think of or that may come about, you can cancel your transaction and use coronavirus as your excuse to cancel. So again, I don't like the way these are written. I don't like how slanted this makes it towards and in this case, buyer or seller. I mean, your buyer could be in the middle of the transaction getting ready to close, and all of a sudden the seller goes, yeah, coronavirus, I'm not selling my house. Pull their house off the market and resell it. And especially with the way the market is right now and how quickly prices are going up, this gives the seller the authority to cancel at any time and put it back on the market and maybe get more money out of their house if their prices have increased.
I did came across one that wanted us to sign it at the end of the transaction, and I just said no.
Yeah. I would strongly suggest if you're the seller's agent, I really wouldn't want to have this as part of a purchase contract. I mean, it is a protection to some degree, and again, hopefully we'll be getting past all this and we can forget all about this virus part can be just something of the past and we don't have to worry about it. And then you can use this as you could use this form to actually cancel the contract. Buyer and seller agree to mutually cancel the contract, and earnest money shall be released to the buyer. So you could use it for that term as well. Additional terms, you can put additional terms into it. So again, hopefully this is a form that we are not going to be using much anymore. I don't like the form. I don't like the way it was written, but was a necessary evil to protect some people. Okay, the next thing I'm going to go over is the cure period notice. And I just want to go over this real quickly because I know that Dell is going to be watching this because he wanted me to record it. And Dell really wanted me to go into the cure period notice because he wants to know how to invoke a cure notice if you have to. So if the cure period notice, if you need to put it in there again, the contract date, buyer, seller, escrow company, premises, pursuant to the remedies section of the contract, buyer or seller hereby deliver notice to the buyer or seller, whichever it is, the following non-compliance with the contract. And then what you do in here is you cite the line and the verbiage from the contract that they are in violation with. And that's really all you need to do in there, and as cite that they are in violation and send it over to them. And then it says, if the non-compliance is not cured within 3 days after the delivery of the cure period notice, the failure to comply shall become a breach of contract. In the event of a breach of contract, review the remedies section of the contract and consult independent legal counsel. So this really, it's a cure notice. It's just telling the other party you're in violation of the purchase contract. You need to get back in compliance, and you have 3 days to do so. If you don't, then it gives the breached party, the one that is breached against, it gives them the authority to that point then cancel and get out of the contract. It doesn't mean that they will, it gives them the option. So this is really the thing that I like to stress is that the cure period notice is not an intent to cancel. That is not what this form is for. It's a notification to let the other party know you're not in compliance and you need to get back in compliance. To protect my client, I'm invoking the cure period notice. But this comes really, I think it needs to be with a conversation. You don't just want to fill out the cure period notice and send it over. You're going to want to have that conversation with the other party because this can be like a huge slap in the face, and people take it as a negative and a slap in the face. So unless you follow it up or make a conversation prior to sending this over, I think you're really doing your client a disservice by not communicating it. Anybody want to add anything with that? All right. Now we're going to go into the HOA addendum, and the HOA addendum we're not going to cover in complete totality today. We're just going to kind of run through a few things on it. So HOA addendum, and this was just updated last June. So the HOA plan community addendum. Who fills out page 1 of the HOA addendum? It says right here, completed by seller at the time of the
Seller.
listing. Seller, not seller's agent, not buyer's agent when they're trying to write an offer. This should be completed by the seller at the time of listing the premises for sale so that this can all be done. Because who knows better what your fees are than the seller? So if they're unsure what their fees are, they should be contacting the association and finding out how much are their dues, how often are they paid, are there any special assessments? If there is, when does it start, when does it end? Is there a master association? Or is there any other association that we should have information on? If there are any dues for that, and how often? And then you go into the fees payable at close of escrow. Transfer fees, association fees related to the transfer of title, the HOA fee, or is there one for a master fee, or is there both? Capital improvement fees, is there an HOA capital improvement fee, or is there a master association fee? Prepaid association fees, if there are any prepaid fees that need to be done, any other association fees paid in advance of their due date, HOA and master association. Prepaids are almost always going to be done by the buyer. Transfer fees are completely negotiable. That's, we're seeing right now that buyers having to pay everything, but in a normal market, that's completely negotiable, those transfer fees. And the capital improvement fees as well. A lot of times capital improvement fees were the seller were taking care of them because it was their property. So that's just generally the way that I've seen a lot of it happen. Disclosure fees. The association management companies can have a disclosure fee of up to $400. So they can charge a fee of up to $400, and they had to put this in here. They had to pass a law on this because these associations, they were charging just ridiculous amounts of money for disclosure fees. So they passed that law, and then they also put it in here that the disclosure fees are to be paid for by the seller. If there's if it's within 30 days or more have passed since the original disclosure statement, then it says association may charge a statement for other documents update fee of no more than $50 if 30 days or more have passed since the date of the original disclosure statement or in the date of the documents were delivered. Additionally, so if they give you your disclosure documents and more than 30 days later you ask for them again, they can charge you another $50 to supply those again. Additionally, each association may charge a rush fee of no more than $100 if rush service fees are required to be performed within 72 hours after the request. And then you put in what the rush fee would be in there if that's what it were. Any other fees that were in there, seller certification. By signing below, the seller certifies that the information contained above is true and complete to the best of their actual knowledge as of the date signed. Broker did not verify any of the information contained here. That's a big piece right there. So even if you as the agent fill this out, the seller is certifying that yes, this is true. And if we just made up numbers and threw them in there, if the seller signs this, that's what they're verifying is true. It puts them on the hook. So that you really want your seller to make sure that they're filling these out. Information required by law, it goes through and what has to be provided by the seller. Copy the bylaws, rules, and regulations. And whether it's provided by the seller or whether it's provided by the association is based on how many units there that are in the complex. If there's more than 50 units in the HOA, then it's the more than 50 units in the homeowners association will give it. If it's less than 50 units, then it's the homeowner themselves has to provide these documents. Copy of the bylaws, copy of the declaration of the CC&Rs, a dated statement containing the telephone number and address of the principal contact of the association, which may be the association manager, an officer of the association, or any other person designated by the board. The amount of the common expense assessment and the unpaid common expense assessment, special assessments, or other fees. Fees are charged annually due to the payable by the seller. A statement as to whether a portion of the unit is covered by insurance maintained by the association. Total amount of money held by the association in reserves. If the statement is being furnished by the association, a statement as to whether the records of the association reflect any alterations or improvement to the unit that violate the declaration. The association is not obligated to provide information regarding alterations or improvements that occurred more than 6 years before the proposed sale. Seller remains obligated to disclose alterations or improvements to the premises that violate the declaration. So that's still on the seller to make sure that they are disclosing any alterations or improvements that may be a violation. The association may take action against the buyer for violations apparent at the time of purchase that are not reflected in the association's records. So just because it hasn't been recorded doesn't mean that it's not a violation, and they can still come back after the buyer. A statement in the names, if a statement is being furnished by the seller, the statement as to whether the seller has any knowledge of any alterations to the unit that violate declarations, and a statement of case names and case numbers for pending litigation. A copy of current budget, a copy of the most recent financial report. If the report's more than 10 pages, the association may provide a summary of the report in lieu of an entire report. A copy of the most recent reserve study, if any other information required by law, and a statement for buyer acknowledgement and signature that are required by law. So you have to have some kind of a form that says, yes, they've received it. So then you get onto the last page, and this last page, that's what's it say there? Note lines 75 to 81 to only be completed by the buyer and not the seller. And especially right now, we're seeing sellers are filling this page out and just marking buyer. That clearly states they are not to be filled out by the seller. The buyer still has to have the opportunity to choose what they want to do. Buyer shall pay all prepaid association fees. Seller shall pay disclosure fees. If a finance purchase, buyer shall be responsible for all lender fees charged to obtain association management company documents. That's a big piece right there. And Dell is he ended up paying something that the buyer's lender needed from his seller. And Dell ended up getting these documents from the management company, and he had to pay to get these documents. And I chewed him out for it because he wasn't supposed to pay that. That's supposed to come from The buyer is responsible to pay those fees. If their lender is requiring documentation, they need to pay for it, not the seller. But so buyer verification, the buyer may contact the association management company for verbal verification of association fees payable upon close of escrow. So that just says the buyer can call to verify. Any current homeowners association fees that is a lien as of close of escrow shall be paid by the seller. Any assessment that becomes a lien after the close of escrow is the buyer's responsibility. Any other terms that we need to throw in it? And then the buyer acknowledges by signing below that they've seen all 3 pages of this addendum and that they are agreeable to all the terms and conditions of it. So that is HOA addendum. Anybody want to add anything into the HOA addendum?
So going back to page 3.
Yes.
So stop right there. It's funny, I was adding, any undisclosed fees are be paid by seller at close of escrow, but it really says, that this just says assessments. Sometimes, a fee or something will come up, so I always put that online, additional terms and conditions. Any undisclosed fees will be paid by seller at close of escrow, obviously when I represent the buyer.
Right. That's a great point in there, Patty, is that sometimes there might be something that doesn't come up until you get ready to close. And all of a sudden the HOA is like, oh yeah, there's this fee needs to be paid in order for us to be able to close this transaction. And whatever it happens to be for, if it hasn't been disclosed to the buyer, it's certainly not their fault that all of a sudden this thing has popped up. So I agree with you at that point. Any undisclosed fees should be paid for by the seller. So I like that. So then down here, you've got the buyer's acceptance and the seller's acceptance for those things right there. Great point. All right. Next one we're going to go to is the multiple counter offer.
The only thing I would add is if, it is just for, if you have a listing and it's in an HOA, you really need to make sure that this form is, page 1 is completed and you've got it in your documents section of the MLS so that,
Yes.
People who are making offers can complete it.
Especially with how fast things are moving right now, you need to have that the same time you get your ER formed and when you get your seller's disclosures back, you should have that HOA form back from them at the same time so that you can have all of that ready to go. And as a kind of a little side note on that, in your ER form, you can even add a little term of that in your ER form that states that listing will not go active in the MLS until all forms are completed and turned into listing agent. That way it's, you have authority that you're not going to take this thing active until you get all the forms that you need to take it active. All right, so the multiple counter offer. So this one, this form I think is hugely important to use. We recently had an agent, not in our office, but in our company, who instead of using the multiple counter offer form, just used a counter offer form and countered back several offers that they had received with just a counter offer form. And
Oh my God.
they received multiple signed counter offers that came back, which means that they had just sold their home more than one time. So they were obligated for things that they could not possibly provide, including commissions for multiple transactions. So it got really ugly, and it ended up costing the homeowner some money, which of course we ended up picking up the bill on. So we ended up, forfeiting a good chunk of the brokers and the agent's commission because we had to try to offset what mistake the agent had made by not using the multiple counteroffer form.
So that tells me that the commission had to be enough to cover that.
Pretty much, yeah, I think so. I think I think we pretty much did the transaction for free, is what it ended up happening, and we just had to settle with one of the other people who, had put an offer in. So it was one of the other people who they had accepted the offer with. They had to, give them some kind of compensation, and the only way that was going to work for them is if they gave them some money. So ended up writing them a check to make that offer go away and for them to release their claim on the property. So multiple counter offer originated by the seller to the offer or to the counter offer. You can do a multiple counter offer to a counter offer. So an offer or the counter offer between the following parties, premises address, acceptance of the above offer and or counter offer is contingent upon the agreement of the following. So then you have your conditions down here. Seller is making one or more counter offer to the prospective buyers on terms that may not be the same as contained herein. So you can make multiple counter offers with different terms to different people. So you don't have to have the same terms for every multiple counter offer that you issue. You can have different terms for each one. Does that make sense? All right, until final acceptance, the parties understand that the premises can be sold to someone else and or either party may withdraw any offer or counter offer to buy or sell the premises. So until this thing is fully ratified, which means that even if this is initiated by the seller, which it is, so if this is initiated by the seller and they give the buyer a chance to respond, that says, okay, you have to respond by such and such date, and that's signed by the seller, the buyer's response, if the buyer responds back and says, here's my response, I'm going to, and you would check this box if you were going to be issuing another counter offer back to them, if you're not just accepting their offer. So if you're issuing another counter offer back, you would check that box, the buyer would send that, and then you would submit your other counter offer along with this form back to them. Or your other option is to buyer's acceptance. The buyer agrees to the terms and conditions of the multiple counter offer and acknowledges receipt of the copy hereof, unless final acceptance of the multiple counter offer is signed by the seller and a signed copy delivered pursuant to section 8M of the contract and received by the broker, 8Q, by X date, mountain time, buyer's acceptance shall be considered withdrawn. So even though the buyer says, I accept, I'm good, I'm accepting this, we're under contract, we're going to go open escrow. Hold your horses, you're not done yet. So the seller would then have to come back. If you had accepted, the seller would have to come back, and seller would either give a final acceptance or their response would be an additional counter offer. So if they issued a counter offer, you can go back and forth, like with your counter offers all over the place. So you can go back and forth with counter offers, or in order for this to be final and for this to be ratified, the seller would have to sign it and deliver it back. Once this is signed and delivered back to the buyer, now you're under contract. Does that make sense to everybody? Any questions on that? So everybody knows how and why we're using multiple counter offer. All right. Yep.
So I had a situation that was interesting on a multiple counter, and this was a few months ago, so not quite in this crazy market, but the the seller countered our offer. We had an escalation clause in it, and basically what they were doing was they wanted us to go to our maximum on the escalation clause, so that they could get the other buyer, so that they could set a price so that the other buyer's price would then be higher than ours. Does everybody follow that?
Oh yeah, yeah. Sneaky.
Yeah, we wouldn't sign it.
No, because they weren't planning on going with your offer anyway. They were only doing it to use you to jump up the other offer.
Exactly.
Yeah, that's just sneaky. All right, on-site wastewater treatment facility addendum. We're going to go into that one. So what would we use this for? Septic, right? So this is your on-site wastewater treatment facility addendum. So we're not going to go through this whole thing completely, but we're just going to kind of briefly run through it here. This just, says that the facility has to be inspected within the last 6 months, and but no later than 20 days after contract acceptance. The facility inspection shall be completed by an inspector recognized by the applicable governing authority. And it says that they will also, they are going to clean out the septic tank and make sure that it's working properly. Document delivery within 20 days or blank days after contract acceptance. Seller shall provide buyer with a report of inspection form completed by a qualified inspector and any other documents in the seller's possession that relate to permitting and operating and maintenance of the facility. Repair costs. This is kind of a big one here because a lot of times once they go to have it pumped and serviced, they may find that there are problems with the septic tank. So if there are problems with the septic tank and if it can't be certified, the seller shall pay to repair the facility, provided that such repairs do not exceed 1% of the purchase price. So if it exceeds more than 1% of the purchase price or blank number of dollars, then the seller has the right to say, yeah, I'm not gonna pay that. But if that's the case, the buyer may immediately cancel the contract, or the seller can cancel the contract unless the buyer agrees that they're gonna pay to have it fixed and brought up to certification. If the facility is functional with concerns per the report and inspection, the buyer and seller acknowledge and understand that they may, but are not obligated to, engage in negotiations for repairs and improvements of the facility. By delivering to the seller a signed notice, the buyer may cancel the contract within the inspection period or 5 days after receipt of the facility documents, whichever is later. So if you don't get the facility documents from the seller until after your inspection period is ended, you still have that 5-day period to review and decide whether or not they wanted to continue. Buyer's failure to deliver a signed notice of the cancellation within the specified time period shall be deemed that they are going to go forward. Notice of transfer. Buyer shall deliver to escrow company a completed ADEQ notice of transfer of ownership of an on-site wastewater treatment facility form. The notice of transfer prior to close of escrow. Escrow company is instructed to file the notice of transfer and the filing fees with the applicable government authority at close of escrow. Notice of filing transfer fee. The notice of filing transfer fee and any other facility transfer of ownership shall be paid for buyer, seller, or split evenly between them. Patty, what have you seen? What's the most common that you've seen on that as far as the filing transfer fee? Who pays that?
Actually, well, I haven't had one recently because now it'd probably be buyer.
Yeah, right now I'm sure it would be buyer because the seller doesn't want to pay for anything right now.
Right. So, but quite often I see the seller. In the past.
Yeah, I had in the past too, but what I found interesting is that it says the buyer shall deliver to escrow a notice of the completed ADEQ transfer form. So the buyer has to fill out the form and supply it, but then the seller would end up paying for it. Normally, that
Right.
was kind of what I saw. It was a lot of times with the seller, but it seems like, if it was a buyer thing, it seems like the buyer should have been paying for it all along. But
Yeah, you're right.
anyway, so that is the on-site wastewater treatment facility. Anybody have anything on that they want to add? All right, a couple of these other ones I'm just going to run through really quick. So the next one is the agency disclosure and election. And I just want to jump into it again real quick, just because I know we've got some new agents that are going to watch this, and I just want them to see kind of what and why we do things the way we do. So we've got one in here for the buyer and for the seller. I'm just going to pull the buyer one up. It's not that they're any different, other than the fact that there's some slight differences to it, but it's just mainly one for buyer, one for seller. So information up there: buyer's broker and how you're representing them, seller's broker, how you would represent them. If you're representing both parties, how that would happen in there. Basically what I wanted to come down to is what boxes that you should automatically check and when you should have this filled out. Ideally, when you have this filled out should be upon your first meeting with your client, before you even show them properties, before you get involved with them. They really need to sign this so that they know how you're representing them, and you have the authority to represent them in the way that they want. So either as the buyer's broker or as the seller's broker, or show them both properties that either we have listed, that the brokerage has listed. So that would be the limited representation. So I would want to check both of those boxes if I'm the buyer's agent, because I'm representing them as the buyer's broker, but I also want to be able to show them properties that would be listed by our brokerage. So check those boxes if you're the buyer's broker. If you're the seller's broker, you're going to be representing the seller as the seller's broker, and you're also going to want to be able to have myself or other agents from our brokerage show the property. So if you're representing the seller, 41, 42, and then box for the seller on line 45. So that's just basically and simply how we would fill one of these out. And again, I would highly recommend that if you're not really familiar with this disclosure statement and what your duties are for your agency disclosure and election, that you need to go back through that form. But I think all of us have been through enough disclosure classes that we understand what our duties and what our duties are representing. All right, so the next one I was going to go into is a quick jump into the referral agreement. And I just filled one of these out yesterday. It was awesome. Love referral agreements. Referral fee agreement. So referral fee agreements are in here. So you can pop them in, and this, you can do these within our company, or you can do them with another company. As you can see, this is the one that I filled out yesterday. So our information, receiving brokerage information, client information, what your referral fee is, how much your referral fee is going to be, or if you want to put a blank dollar amount in there, and then what other documents you want to have from them when it closes escrow. And I want them to send me a final settlement sheet. Why would I want them to send me a settlement sheet?
So you can make sure you were paid appropriately.
Exactly. They can tell me whatever they want, but I want to see what that settlement sheet says. What did they take the listing at? And I want to make sure that I'm getting the 25% of what the actual amount was. And then the referral agreement starts on as of yesterday, and I have it running through August 31st because I know this place that they're selling in Houston is going to sell within a matter of days. So with the consent of the originating broker, has received the client's permission to initiate this referral or has not. If it's a relocation company, you can say either is or is not aware that it's a relocation company. I should have checked that box. I actually did when I signed it, but I should have checked that box because it's not part of a relocation package as far as I know. So just goes through the rest of the information there. Charlie's name goes on there. I can sign these, but Charlie likes to still sign the referral forms. So send them to Charlie for his signature. And if you don't mind, just include me on it so I can see that there's one that you've sent. But Charlie still wants to sign the referral fees. Any question on that?
I do.
Yes.
For the time you on this particular agreement, you put for only for like 6 months or 7 months around that time.
Yeah.
Do we decide for how long do we want to make this agreement? Is it
Yes, you can decide whatever you want. And I would have a conversation with the other broker and find out, how long do you think it's going to take to sell? So that way you can make sure that, your referral is going to still be active in the amount of time that it's going to take to sell the property.
Oh, okay. Thank you.
You're welcome. All right. Just reading that little piece there about conditions of payment. Kind of interesting. All right. And now the next one we're going to go to is the solar lease addendum. And again, this is the solar lease addendum is a very important part of the contract that if you, and especially right now, because it's such a seller's market, people who were not able to sell their houses before that had these horrible solar leases are now able to actually get their properties sold because the terms of their solar lease aren't nearly as important. People are willing to pay it just so they can get the property. But you still need to make sure that representing your buyer, that you are, making sure that they understand what the terms and everything of the solar lease agreement are and making sure that they can qualify for it and, that they're not going to be getting into something that's going to be, just a money pit. So again, the top part is the same. Following additional terms and conditions are hereby included in the contract. The solar system is installed on the premises is subject to a lease or an unpaid loan. The solar system shall convey with the premises and pursuant to the terms set forth below. Buyer's purchase of the premises is contingent upon the buyer's assumption of the lease. Says who the lien holder is, the seller's disclosures within 3 days. They've got to give you a disclosure about all the documentation they have on it and its functionality. The solar system lease and other documents in the seller's possession are collectively herein referred to as solar system documents. The buyer's due diligence, the buyer needs to do their due diligence on solar. So Again, this is something that you're going to really strongly suggest to your buyers that they get that solar system checked out and make sure that it is functioning properly. And that, again, they're not buying something that's going to end up being a money pit down the road. So they should check on the age, end of lease terms, grid tie-in, homeowners associate insurance coverage, maintenance, output and production guarantees, payment increases, taxes, utilities, utility bills, utility and lesser fees, and warranties that may go with them. So those are things that your buyer should be researching during their due diligence period. If they disapprove of anything, they have 5 days after receipt of the solar system documents, and end of the inspection period, or 5 days after they receive the documents from the seller, to notice that either they want to continue or cancel based on what they've got. They've got 5 days to review them. Buyer's obligation to complete the sale is contingent upon the buyer's obtaining from lessor approval to assume the solar system lease loan under the existing terms and conditions no later than 3 days prior to close of escrow. Are you guys having any problems? Are you seeing any problems with getting the solar companies to get the transfer information and getting everything set forth in a timely manner to get things done? I had heard that there were some issues that people were having with people like Solar City and guys like that, and getting the leases transferred was taking an extraordinary amount of time.
Yeah, so I had one, my last deal that had a solar, Tesla. They were just terrible. I mean, we ended up, it delayed our closing for a week. And literally, buyer and seller from day one did everything they were supposed to do. The buyer jumped right on and submitted his, application. They all did their paperwork, but Tesla was absolutely terrible.
Yeah, that's what I had heard. All right, so we go through unfulfilled lease assumption contingency. The contract shall be canceled and earnest money returned to the buyer if they cannot get qualified for the solar lease. Buyer and seller acknowledge and agree that the brokers are not qualified to advise on solar panels. Boy, is that an understatement. Because conducting due diligence with respect to the solar system is beyond our scope, buyer and seller are holding us harmless. So that just kind of goes through that. Pretty basic and pretty simple, but it just really, it's an opportunity for your buyers to understand what they're getting into as far as a solar lease goes. And I think that's a big piece. The last thing I wanted to jump into real quick, we're right at 2:03, so we're running just a couple minutes late, but I wanted to finish this up. The last one I want to go into is the unrepresented seller. And especially in today's market, when we're trying to find listings, when we're trying to find, houses for our buyers, we're coming upon, for sale by owners. And it's really imperative that you get this signed off on before you take your client over to that house. If your client goes over to the house with you and the seller refuses to sign this, guess what? You're not getting paid unless you have a buyer broker agreement. So you want to make sure that I would always call the for sale by owner first and try to jump by the house and go, hey, can I come by? I want to take a quick peek at it. I've got clients that I want to bring over to the house, but before I do, I want to know, are you working with agents? Yep, absolutely. We'll pay agents. Great. I've got a quick form that I want to bring over to you, have you sign off on real quick. I'll take a quick peek at the house and then I'll bring my buyers by. So it's a simple piece that you can just say, and you can say it as simply as that. And that most sellers, if they truly are working with agents, they're like, okay, come on by. So then you go by and you get them to sign this form, have the compensation form filled out for them, agreement between the buyer or between the seller and you, the broker. It commences on such and such date, ends on such date. And then it also protects you that if within a certain number of calendar days after the termination of the agreement, if the buyer that you brought in buys the house, you still want to be paid. So it goes through that buyer's agency, and it says the agreement is a compensation agreement only, and that we are not representing the seller. We are the buyer's agent, period. So making sure that they understand that. Also goes through, it says any dispute or claim in the law arising out of this agreement shall be submitted to mediation. Cost of the mediation shall be split equally between the seller and the broker. So if you have to go through mediation, that goes through that piece. So that just kind of finishes everything up here. Does anybody have anything they want to add in on unrepresented seller form? All right. That is what we have for today. We've covered all the addendums that I wanted to get through today. We went through 13 pieces today. That's a lot of stuff. So we got a lot of stuff in today. Next week, we are going to do a CMA. We're gonna go through and we'll probably do it a couple of different parts on the CMA, a couple of different methods and ways of doing a CMA and how to perform one. And it's like doing an appraisal. Everybody's going to come up with different values. It's the same with the CMA. 10 people can do a CMA on a house and they're going to come up with 10 different values for the property. So it's always fun and interesting to get other people's take on that. So we'll be asking for others to share next week as well when we do that. But that's all I have, guys. You have anything else to add before we jump off?
Nope. Thank you.
All right. Thanks, guys. Thanks for jumping in. Greatly appreciate you guys being here, and thanks for participating.
Thank you, Todd.
Right.
See you. Bye.
All right.
Ciao.
See you later.